Hi everyone, my name is Madelena Viksne and I am an associate in the employment group at Samfiru Tumarkin, LLP, currently in Vancouver, but I also work in Toronto. Today I thought I'd start out by talking about some of the concerns now that more employees are pushing for hybrid work environments than previously to the pandemic. Um, Obviously, there are employer concerns with respect to hybrid work environments in the event that it's not necessarily required due to safety concerns and so on. Part of that comes from different tasks and so on that you may not be able to complete from home, client meetings and things like that. Um, in the event that you need to navigate a hybridized working environment or you require a hybridized working environment as an accommodation, um, the most important thing is that you speak with your employer. It is important that you are bringing these issues forward to them. For example, if you have childcare requirements or you're higher risk for COVID than maybe somebody else is, your employer doesn't necessarily know that that's the reason for the basis of your request for a work from home or partially work from home situation, unless you raise it with them. They're not mind readers, and it's not possible for them to just kind of know what it is that you need, require, or prefer. Um, Now, with respect to a preference, it's not required that your employer accommodate you for personal preference um, in terms of sort of what your working environment might be like. Just because you liked working from home better, you liked the flexibility of it, um, doesn't necessarily mean that your employer is going to be on board with providing that to you. That being said, however, we have found very often that when employees come to us and are concerned that their employer possibly doesn't seem so on board, if they do go to their employer respectfully and with reasons and with a basis for the request, um, more often than not, the employer is willing, especially if you're a good employee, the employer will be willing to at least sort of explore the possibility with you, work with you to come up with some other solution if the solution that you're requesting just isn't possible, um, or maybe see if there's something that somewhere you guys can meet in the middle. So as I said, your employer is not a mind reader. You also have to remember that you are one employee of probably many. So it is critically important that you bring this forward to your employer yourself, as uncomfortable as those conversations can sometimes be. It is kind of up to you if you're requesting a change in your working situation to raise that with them, in order for them to understand what your concerns are. Now, that being said, I was speaking about personal preference. In the event that you do require accommodation, whether medical or family status or something other than that, it is a good idea to have something to support your request. For instance, a doctor's note that says, doesn't have to give any kind of diagnosis, but sort of explains that your doctor supports a work from home situation for you. In the event it has to do with childcare, it's a good idea to have explored other options that are available to you and be able to demonstrate to your employer, listen, I called these 7 different daycares. I've spoken to these nursery schools. I asked my in-laws and no one's able to help on these days. It would really help me out if I could be at home, and be able to provide the childcare myself. I require that accommodation in order to continue working, but I would be willing to work with you to find a way that we can make that flex arrangement work. It's always good to be cooperative if you can be, and in the event that they absolutely refuse, when it is an actual accommodation that you're requiring under the Human Rights Code, if that's the situation that you're facing, then it's a good idea to speak to an employment lawyer and call someone from our firm to discuss your situation more more clearly, so that we can provide you with sort of next steps and guidance in terms of how to proceed. A question from Tracy on Facebook: if I'm fired, can I still file for unemployment? Assuming you mean employment insurance in Canada. If you've been fired, it depends. The classic lawyer answer, but it depends. There's a number of changes that happen with EI entitlements. Um, if your termination has to do with vaccination, there were different codes that had to be used. The best resource for you is Service Canada. That being said, oftentimes when I speak to people shortly after they've been terminated, especially if their termination is being disputed. For example, they were fired for cause and they've spoken to me and it doesn't sound like sufficient cause for termination. I normally recommend that you apply anyways. EI will contact you or Service Canada will contact you and you can explain the situation to them. If you were not wrongfully terminated, they're going to look at essentially the code that was used on your record of employment by your employer, which you can access through your My CRA account. Or you can call Service Canada and ask them. They're going to look at that code and they're going to use that code to determine whether or not you are disentitled. You can appeal throughout that process. So if you are initially denied, but you feel like that was a wrong decision, you can circle back to EI. EI will also, Service Canada will also contact your employer to find out their side of the story. So just be aware of that. But there is no penalty for applying if you're not sure. However, Service Canada is definitely a better resource in terms of getting answers on that type of question. Anything to do with government resources, they're really who you should try and contact. Archie from YouTube asked, how likely is it that you can be fired for cause if you've been put on a performance improvement plan? My nephew's been put on one, but hasn't had any other complaints at work so far. So a performance improvement plan is a stepping stone towards termination. It doesn't necessarily mean that you will be terminated, and it doesn't necessarily mean that you would be terminated for cause. Generally speaking, it depends on what the issues are with the performance improvement plan and how attainable the sort of goals that are set out are. So when you're put on a performance improvement plan, it generally is something that's concerning and maybe worth speaking to a lawyer. Certainly you should retain a copy of the performance improvement plan that was provided, especially if you were asked to sign it. If you didn't sign it, it's relatively meaningless. If you did sign it, then it is a binding agreement that you're making with your employer that says, listen, this is the plan that we're putting in place to try and improve X, Y, or Z. Whether it's, mistakes that are being made or actual sort of interpersonal issues that are happening that are interfering with work performance. There's a number of different things that they can put in place. One of the main concerns is that it is effectively sort of in between. There's something called progressive discipline. So you'll get like you should, if progressive discipline is being used, get verbal warnings and then written warnings and then potentially something such as a suspension. The idea is that a just cause termination is extremely serious. The courts have said that it is sort of akin to capital punishment in employment law. So because of that, the employer really needs to demonstrate that they have taken other steps that have led them to a point where they've decided that they don't think that it's possible for the issue to be resolved, and it's so serious that there's nothing else that can be put in place to try and resolve the issue. So because of that, if you've gotten a performance improvement plan, it sort of falls somewhere between a written warning and something like a suspension. So it is something to be taken seriously. But it doesn't necessarily mean, as I said before, that you'll be fired for cause. If you are hitting all of the goals that have been put into that performance improvement plan by you and your employer, and it should have been sort of somewhat of a discussion between, in this case, your nephew and his employer, there should have been some discussion in terms of what goals were attainable, what checkpoints were going to be sort of looked into along the way. So, at 1 month, he's going to meet with his manager and they're going to look at X, Y, or Z. and 2 months they're going to reset those goals so that by the end of the 3 months hopefully he hits his point. They shouldn't really be longer than 3 months without some evaluation in that period of time. If he has further questions, so he's welcome to contact our office, of course. Jordan from Facebook asked, I work on a fixed term contract and my employer has said they want to extend this. How soon before the end of my contract period do they need to provide a new contract and make the offer? So you can't really extend a fixed term contract. Your contract will end on the date that it is already set to end, assuming that it's a year-long contract. If it's shorter than that, they can certainly extend it. But if it's a year, then you're essentially going to be signing a new contract at the end of the term. There isn't really a strict rule in terms of when they have to provide you with the offer or provide the new contract. If you're going to be signing a new contract, this is a point in time where you can negotiate terms. It's also a point in time where you can ensure that you have sufficient time to have a lawyer review that contract before you continue. If you've been on fixed term contracts for more than one time, like this is more than the first time that they've extended it, it may be worth speaking to somebody to understand sort of what your rights and entitlements are with respect to a fixed term contract, if there have been a series of them. But there is no specific date to your question. So Zozia, I'm sorry if I've said that incorrectly, said, I was laid off last November after 18 years of working for my company because of the mandates. I wasn't offered any severance package. I was wondering what I have to do. And I'm not sure what the last part is, but if you were laid off in November as a result of the mandates, the law is still very unsettled in this area. We haven't had any court decisions that necessarily have confirmed or denied whether or not the mandates did in fact allow employers to do that. Our position is that they are not allowed to lay you off without your consent. At common law, that's the truth in a general scope. That being said, the mandates and COVID have all created sort of these unique scenarios where we aren't able to be 100% sure about some sort of outcomes. So there is a risk in bringing a case forward with respect to vaccination or termination resulting from vaccination because, the courts haven't spoken to this yet. So the law is not settled and established. Now, that being said, it certainly would be worthwhile speaking to a lawyer. I would recommend that you call our office and contact our intake department to set up a call with somebody. Especially after 18 years, it's possible that you have entitlements that would be relatively significant. Make sure that you have copies of the vaccination policy and any layoff letters and so on that you can provide to us, as well as your employment contract. A lot in terms of what our recommendations are will depend on the language of the policies, your industry, whether or not specific government mandates actually did apply, because the mandates themselves, there was only a mandate for federal employees in Canada, and it was a specific group of federal employees. So outside of that, most of what happened was actually just based on recommendation, not actual requirement by the government. The same is true for some of the shutdowns that happened. In some of those cases, it was mandatory, or the capacity restrictions were so limited that it was impossible for some places to continue to operate. But not every single place that shut down or cut their capacity was actually mandated to do so. So there's more information that we would need. So I would recommend, Zozia, that you contact someone at our office so we can explore your particular fact scenario a little bit more clearly. Archie is circling back, saying he was given a verbal warning for punctuality once, which was then followed up directly by the plan. He wasn't told anything else beyond don't be late. So it doesn't sound like it's an exactly fully a performance improvement plan. Generally, they'll have sort of specific goals, and here were the performance issues that we noticed. Here are the sort of different ways that we're going to measure your improvement on those. Here are the meetings that you're going to be required to engage in. And then here is the like end goal. The performance improvement plan itself should say something along the lines of, if improvement isn't seen, you will face further consequences up to and including potential termination. Based on your question about just cause, it seems like it probably does include that language. But that being said, for just being late, I would have to know more in terms of what the issues are, if there is potentially some human rights issue that could come into play and make their response to it, to him being late a couple of times. How often was he late? Is this an absenteeism issue as well? Is he not showing up or just not being on time? Is there some medical reason or some protected ground-based reason that is preventing him from being on time that he's disclosed to his employer, who is now ignoring that? All of those factors would come into play. So I would recommend that if he has concerns, that he potentially speak to someone in our office to go over the plan, to go over what the possibilities are in his particular situation, and possibly set up sort of a plan for moving forward, depending on which way things go. Am I obligated to approve unpaid personal leave if employees have used up the vacation entitlement and ask for more vacation time? It depends. So this question is, am I obligated to provide unpaid personal leave if employees have used up their vacation entitlement? You're saying they're asking for more vacation time. It sounds to me that if they're asking for unpaid personal leave, it could fall under a protected ground, or a protected leave under the Employment Standards Act. In Ontario, at least, we have a number of different protected leaves, such as caregiver leave, family leaves, sick leaves, maternity leave, paternity leave. All of those are unpaid leaves, except for a couple of paid sick days that are in place now. But generally speaking, if it's one of the leaves that they're entitled to under the Employment Standards Act, you would have to be very, very sure that it is not before you deny that unpaid leave request. They may not be using the correct language. You have to remember that when you're speaking to your employees, they are not lawyers. They maybe don't fully understand their rights, but they may have an idea or understanding that they are entitled to, for instance, a critical illness leave of absence, or a family caregiver leave if somebody in their family has taken extremely ill and there's the possibility that they might require care or even pass away within a certain period of time as defined in the statute. They may have this idea that they know that they're able to ask for it, but they may not be calling it the correct thing. So to cover your bases, I would suggest that you speak with employment counsel in your province, and make sure that what they're requesting is not what does not fall within one of the categories of protected leaves, because you can end up in definitely hot water if you are denying a leave that they are legally entitled to. That being said, it may require more investigation on your part as well. If you have a suspicion that, or you have some inkling that someone in their family is sick, for instance, and that's why they're asking for this personal leave, you may want to ask more questions about that in order for you to determine whether or not you're obligated to provide it. Now, Tina from YouTube has asked, if I feel I'm wrongfully being put on a performance improvement plan, I don't agree with those and indicated in my email, but I was informed that even if I don't sign it, it would be in effect when they fire me. Is that right? I mean, technically, your employer, I suppose, could be putting notes in your file any day, and not necessarily having you sign them. Best practice is that you're asked to sign these types of things. But is it required for it to be enforceable? In my view and in my understanding, a performance improvement plan should be signed by the employee, because it's not actually, as much as it is used by an employer often to sort of solidify a termination, or as a step towards termination. Um, at the same time, just by its name, you can see that it's intended to allow the employee some amount of time to improve whatever the biggest issues are that the employer is seeing that are sort of leading them down this path. If you don't sign it, there's no way to acknowledge that you know about it. I suppose in your case, you sent an email that says you don't agree with the terms. Have you tried working with your employer to come up with sort of goals or thresholds, targets that would be more agreeable to you? It's a good idea always to work cooperatively with your employer if you're able to. Now, again, just as I was saying to Archie, I don't know exactly what the specific situation is that you're dealing with. I'm not sure what your performance improvement plan is about. You don't have to disclose that on here by any means. I understand that it's private, but there are certainly reasons to contact a lawyer if you've been put on a performance improvement plan, especially if they're talking about termination. It's a good idea to sort of get your ducks in a row, so to speak, to understand what your potential consequences are, to understand what your obligations are pursuant to the PIP that you have been provided, whether or not you've signed it, and have a better idea sort of overall of where this could go and what you should be doing in the event that it does go one way or the other. Also, there's strategic ways that you can deal with your employer where you might be able to have a bit more say in terms of what the metrics are and so on, and come to a resolution that's more agreeable to both of you. From Alana on Facebook, she's asked, how long can I be placed on a layoff before I can ask to be given severance? I mean, there's not really a hard and fast rule, I suppose. It depends on what the situation is. If you are if your employer is contractually allowed to lay you off, if there's a term in your contract of employment that says that you've agreed or that you are governed by the Employment Standards Act layoff termination provision or layoff provision, so on, then you would have to wait until the end of the statutory period of time, at which point you should be receiving severance if you have, or termination pay. And if you haven't, then it would be a good idea to contact our office if that period has passed. That whole analysis is a bit changed under the COVID times with infectious disease emergency leave. Obviously, through that period of time, those sort of timelines were altered. So it would depend again on when it was that you were first laid off. Also on whether you have that your employer has a contractual right to lay you off, because if that's the case, then you may not be entitled to severance at all. There's a number of other factors, such as whether or not you've been laid off traditionally or historically throughout your career with this employer, and accepted that layoff and come back to work. If that's the case, then it's possible that they can rely on those past layoffs to say, she's always been an employee who we've been able to lay off. There's no reason that would change now. It doesn't necessarily have a straight answer. So Alana, I would suggest that you contact our office and speak to somebody about your particular circumstances so that you can try and determine which of the factors in terms of timelines might apply to you and your layoff specifically. Make sure you have copies of any layoff letters, or at least the dates of those layoffs, as well as a copy of your employment contract if you have one. May, you're very welcome. And Julia says, I feel I have been discriminated against by my employer and treated unfairly. How do I prove this? And what are my rights if I need to leave my job because of discrimination? So this is a very broad question, Julia. It's very difficult for me to speak to an answer at this point, given that there's no specificity with respect to what kind of discrimination you feel like you've experienced, what it is that's leading you to be treated feel that you've been treated unfairly, and what the basis would be, what it would be that you would be trying to prove. So discrimination just means differential treatment. There are most of the time people are talking about differential treatment on the basis of a protected ground under the Human Rights Code or one of the human rights codes. So that would mean something like racial discrimination, discrimination on the basis of sex, medical disability, family status, marital status, and there's creed. There's a number of protected grounds, so that is not an exhaustive list. But if you feel like on the basis of one of those protected grounds, you have been treated differently than other people in your workplace, that could potentially be discrimination. Probably the best thing for you to do at this point is to keep a record of any interactions or instances that you sort of are that are leading you to feel this way, with as much detailed dates, all of that stuff as you can. Your employer is not allowed to discriminate against you, legally speaking. But I guess what I'm kind of struggling with here in terms of answering your question is I don't have enough information at this point to advise you as to whether or not there's something to prove, to advise you as to whether or not on a legal basis, what's happening to you amounts to discrimination, that would be provable or would, grant you certain rights in the event that you leave your job. Being treated differently or being treated unfairly doesn't necessarily establish discrimination at law. Is it wrong? That's obviously, could certainly be wrong without amounting to something like harassment or discrimination from a legal perspective, where it is provable and where it does afford you some sort of rights. So I would suggest that you sort of create some sort of a timeline or document in some way that sets out what your experience has been and what it is, with as much specificity as you can, what it is that you are referring to as discrimination. And then contact someone at our office, our intake department at our office, to set up an appointment with somebody who can go through ahead of your consultation, read what it is that you're sort of alleging or bringing forward, and be able to advise you more specifically. John from Facebook. So this is going to be my last question, everyone. Thanks for showing up today. But John from Facebook has asked, is there a limit to the amount of working notice an employer can provide? Is it legal for my employer to give me 1 year of working notice? Working notice is not, technically all notice should be working notice. It depends, I suppose, in terms of your case, on what your situation is. So pay in lieu of notice, which is what most people receive, is an alternative option to working notice that your employer should be providing you. Working notice, it depends on what the timeline is. Depends on whether you are governed by an employment contract that has a enforceable termination clause, whether only the ESA applies, in which case 8 weeks is the amount of working notice that they're required to provide. Your employer could certainly provide you with more working notice, but they can't provide, if you're entitled to severance pay, they can't provide your severance pay by way of working notice. Severance pay under the Employment Standards Act in Ontario is always paid separately. It can't be worked. So again, depends on what the terms of your employment contract say. Usually if the working notice period is that long, it's often because the employer is selling the business or the business is being shut down and they already have a particular date. Um, there's not technically anything wrong with them giving you a year of working notice, as long as you're also receiving any other entitlements that you're required to be provided. And also, one of the most important things is that during the working notice period, nothing should change. Your pay, your benefits, your wages, your wage rate cannot be decreased. You still are entitled to your vacation pay. Everything that you would have been entitled to receive but for the working notice. So if you were just continuing on in your job as per usual, you will continue to receive it, or you should continue to receive it. You can't be laid off during the working notice period without pay, because obviously then they've changed one of the terms of your employment throughout the working notice period. That's just an example, but hopefully that gives you a bit of clarity in terms of what to expect. All right, thanks very much. So I'm Madelena Viksne from Samfiru, Tumarkin, and we hope to hear from you if you have any questions, and we'll be back next week. Thanks.